Um, so I guess let me do the quick introduction. So my name's Christina Jimenez. Introduce yourself, gentlemen.
I'm Josh Floyd.
I'm James Pailin.
And we are all attorneys over at the Jimenez Law Firm, and we are a Texas-based law firm. We do family law, criminal defense, and we have been doing this Facebook Live now for a few weeks. And basically what we do is we take the opportunity of the time to discuss different questions, fact patterns that are relevant to different people. We always caution everyone at the beginning and at the middle, and most of the time at the end as well, that when we are going through these fact patterns, that it's not supposed to be legal advice, right? It is us kind of just discussing these particular people's situations, and your situation could potentially be different. So it is so important that you kind of take this information with a grain of salt. You go out, you talk to your own attorney, you hire your own attorney, and let them know your specific situation so that they can help you, okay? So with that being said, this morning we do have James. So James is a new attorney over at our firm, and he's gonna be helping us out today. And then as always, we have Mr. Floyd. Mr. Floyd, I'd like to discuss something with you.
Uh-oh.
Can you identify this gentleman?
Oh no. Oh no.
I do not recognize him.
What were you thinking, Mr. Floyd?
I thought it would be funny, and I was correct.
So do you want to share the background story to this gentleman here?
Yeah, I guess so. So not this past week, but the week before, in the 446 docket, I had logged on to the wrong hearing link.
Mm-hmm.
And so judge is texting me like, hey, we're waiting on you. And so I realized what I did, so I go over to the correct link. And since I was late, her and Mr. Norris had been talking about my punishment for contempt for being late. And one of the things that they threw out was me having to dress as a clown for docket call or for court that day, whatever it is. And then they decided that that wouldn't be beneficial because it wouldn't bother me. And so I thought it'd be fun to dress as a clown for court, and I did.
Was it indeed fun or?
It was a blast, yes.
It was not fun for me, James, in case you were curious, because all I get about 5 minutes before docket call was a text that I cannot be terminated for anything that happens within the next hour. And so
Oh my goodness.
does those goofy backgrounds and stuff. And so I thought he has a background in docket call that I'm not going to approve of. And so I immediately told him, take off your freaking background and stop whatever it is that you're doing. And then I hear crickets. And then like within a minute, the video pops up and I see this fool.
Yeah. I remember that docket call like it was yesterday.
Well, both James and I had our heads down like, golly. Floyd, you could have at least warned us so we could have been like cool at least.
Right.
Oh my gosh. But like here's the thing, and it's like it's like a love-hate thing that I have with Floyd, is he goes all in everything. And so it's wonderful when it comes to cases and clients and all of that stuff, right? But when it comes to this, yeah, I just don't understand it. I don't understand why, if we are doing Zoom, we have shoes on. I just don't get it. Like, I don't know.
Well, I tell my kids, look, we don't half-ass anything. We whole ass it or we don't do it. And
well, you went all in. So excellent work, I guess.
Yeah, I respect the
James
principle.
called me afterwards, like, dude, you could have at least given me a heads up.
Come on, man. What am I gonna do, right? Just
James, you wouldn't have called me and said, Christina, you need to know something. No?
I might have sent you a text like, hey, look, you know, Hope you're having a great morning.
Oh, thank you, James. I appreciate that. Oh my gosh, Floyd. I still like all weekend I would think about it and I would just get embarrassed. So secondhand embarrassment. All right, with that being said, okay, so let's start going through some of these questions. Floyd, why don't you go first?
I should have worn the clown thing today, actually.
Oh
That would
my
have been.
God, Floyd, no, it's done. It's been done. You can't do it again.
Actually, James called me Friday. I was like, hey, so is there any dressing up I need to be prepared for on Monday? I'm like, wear a polo or a button up or whatever. He's like, no, I mean like dressing up. Is there anything I need to be prepared for?
Oh, you're smart, James. I didn't even think to ask him.
See, now I gotta prepare myself.
Okay. Question number 1. When we divorce, can the house stay in both of our names if it's not paid off? So we just moved into a house and have a few years before it's paid off. Refinancing it may not be an option for either of us. This was supposed to be a short-term home anyway, because this is where we need to be for our daughter's heart surgeon, and we plan to sell it after paying it off. Would it be possible to keep the house in both names, me and the kids living in it, and have us split the house payment so we can sell and split that later? All things are possible. So yeah, if there's an agreement, then there's no problem with it. Generally, courts won't get in the middle of an agreement that two parties have. And so if both of you agree to do it that way, that's fine. However, if there's not an agreement, generally speaking, the judge will give, 90, 120, 180 days for one party to refinance and remove the other party's name from it. Of course, refinancing it for an amount sufficient to give the other party their equity or however the property is divided up. But yeah, so possible, but only by agreement. I think that if it goes contested, not very likely. And I guess it doesn't say how much more they have on it, because she said, oh yeah, a few years is paid off. Yeah, so I don't think the court's going to let you live there for a few years with it being in both parties' names without refinancing it unless that's by agreement.
Yeah, but I mean, they're gonna split the house payment, so that's cool, and they can sell and split later. I would want to know, some additional issues like who's gonna pay, I guess property taxes and insurance, because they still have a mortgage would still be included, so that's good. The only thing that I guess would kind of concern me is for the husband, because if he's moving out and he has this big note on his credit, then if he decides that he wants to go and purchase a new home, depending on what his income is, he may not be able to do that because of his debt to income ratio. And so as long as he understands that and he wants to make that sacrifice, then I think that is perfectly cool. And it's good because clearly these two are thinking about their children and not themselves. And so that I think is always what is best. So
Doesn't happen often enough, for sure.
that is for sure. Yeah. Okay, so next one. How can I get the back money child support owes me for taking out money from my SSI when I stopped getting support 2 years ago? So my son's father was paying me child support. They would take $400 out of my SSI because child support payments were for my son, I guess. My son hasn't been in school for 2 years. He went straight to work, yet they're still taking money out of my SSI. How can I get the money they have taken and get them to stop? I don't understand this question. So I don't understand why they would be taking money out of her SSI if the father was paying her support.
Next question. I don't get it either. Well, you could just answer generally if there was an overpayment
Oh, so we can make our own questions now? That's what we're gonna go down this path like we normally do?
No, we're not making our own question. We are not answering the unclear portion of the question.
Okay,
It's going straight to, how can I get my money back if I've overpaid?
okay, got it. Okay, so can I answer that question? I do know the answer to that question.
Yeah, you can give it a shot.
Okay, so if you've overpaid child support, and this unfortunately it happens a lot. I just actually had a hearing on this last week. So if you overpay support, you have to file a petition to recover overpayment of support payments, something like that. I can't remember the correct full name, but it's something like that. And basically what you do is you go in and you allege that you have paid more child support than what you were supposed to because the child emancipated, the child graduated, passed away, turned 18, whatever it is that would trigger this, or came to live with you. There's all sorts of different reasons why you could potentially try to get this thing filed. From that point forward, you file a motion with the court, set it for a hearing, you allege, how much you've overpaid, the court does a calculation, and if the court finds that in fact you did overpay, they will order the other parent to repay you. So in this particular case, you're not going to recover anything from SSI. It's all going to have to come from the parent that was receiving those payments. And then typically when that happens, they can set them up on a wage withholding so that it's automatically taken out of their check and then paid to you. So pretty easy.
Yeah.
James, you are up.
Okay. Let's see here. Do I still have to pay child support in Texas if my child dropped out of school and left home before he turned 18? Okay. My son dropped out of school and left my ex-wife's home and has been self-supported since February 2nd of 2020. I continue to pay her child support and paid it off early, or as early as August 22nd, 2021. My ex-wife has asked the OAG to continue payments until January 1st of 2022. Do I have to pay this? Okay, so a couple of issues here. So if your child is, well, first thing, child support obligation is until the child turns 18 or graduates from high school, whichever comes later. So that's the first thing. So it sounds like your child has dropped out of school and more than likely is living with someone else, probably not living on his own at 17. So your obligation would still continue. Perhaps not to the mom, but to whoever the family member is who the kid is living with. Or on the other side, if the kid has been emancipated, then their child's disabilities have been removed and they are walking around like a grown person. So in that sense, I think, yeah, the situation is a little bit different. So under the first scenario where kid is moved in with someone else, you could indeed file a modification and see if you can get that kid back over to your place, put the kid back in school, and then send them on the right.
Let me interject there, James. So he could file that modification to try to get this kid back, but the problem that I would be worried about is what if when he filed that, the adults that he was living with, assuming that he's living with an adult, decided to file some sort of modification on the father and the mother to say, hey, I'm now supporting this kid. I want child support to come to me, right? And so it wouldn't have the effect of potentially canceling the support if he was trying to fight for custody, right? So that would be a concern, but would that probably be best for the child? Yes. It's just something that he's going to have to be kind of cognizant of if he wants to take that risk. What was the other thing you were gonna say?
The other thing, if the kid has petitioned for his emancipation, where walking around like a grown person, then wouldn't the child support obligation be done and finished as far as the father is concerned?
It would be, and we actually, what have we done, like one of these Floyds where we tried to do the emancipation, or we did do an emancipation?
Yeah.
I can't even
I don't
remember.
remember much about it, but I remember it being difficult.
Yeah, there's like so many different factors that, and so the child actually has to file a petition to court, right? And the child has to say, this is why I believe that I should be emancipated and that I'm able to be, an adult in this particular situation. And so it's not something that just naturally happens. There's a process. And I remember it being, can't remember exactly what we had to do, but it was kind of a convoluted process at that. And so you typically don't see emancipations that actually get processed. It's more like the situation where the kid just takes off and nobody has any control over him. Nobody knows what the heck they're doing with him, and you're stuck paying child support. So I guess in theory, what he could do, and probably what I would do if I represented him, is I would file a motion to modify and just serve the XY for the mother, right? And basically file a motion to modify my child support obligation, requesting that it be terminated because she no longer has possession of the child, right? And then at that point, in theory, the mother can notify the other parents that this kid was residing with, if he was residing with someone. And then that person would then have to intervene in this suit if they wanted to mess with the child support at all. A lot of times when you have situations like this, the people that actually have the kid, they don't even want to mess with that. They're just trying to do a good deed and just help this kid and push through, right? And so in theory, if dad filed that against mom, then and mom told them and they didn't do anything, or mom didn't do anything because she didn't have the child, or even if mom showed up to court and said, well, I don't have the child, but I still want my child support, I still think that there's a higher probability that his child support would terminate at that point. But he has to file a motion, he has to go to court in order to get all that stuff done. Otherwise, he's still on the hook.
Yeah, I kind of like James's point earlier where you fight for a primary, right? I mean, I understand there's a possibility of intervention, right? But we all know the parental presumption, right? That it's presumed to be the best interest that the child live with the parent. It doesn't say how long the child's been living with this other person or how long dad has known about it. But I think what James was saying, I agree that his obligation continues, right? It's just a question of to who, right? Is it to mom anymore? Is it to this new person? But if the child's dropped out of school and dad comes in and says, look, child's not going to school, child's living with some random friend at this point, I want primary to get my child back in school. I don't think the interveners, number one, depending on how long they've been there, right, would have a good shot because of standing. But two, I think that would really increase dad's probability of winning primary and terminating his support. The thing is both parents have an obligation to support, right? And just because you're receiving child support doesn't mean you're not spending money on support of your child. Actually, you probably spend more than the person that's paying child support, right? So either way, I think the obligation continues. It's just to whom it's being paid.
But Floyd, how many times have we had this conversation about making angry 17-year-olds come into your home?
Well, I don't have to live with them, and so
I mean, again, in theory, it is a great idea, but in all practicality, and we have to have these conversations with our clients quite a bit, right? Where they're so upset because their 14-year-old child or the 15-year-old child or 17-year-old child doesn't want to see them or doesn't want to come to their house. And they want to enforce their visitation, they want to fight for primary, they want to have rights to their children. And typically my advice is you have to work on your relationship with your child before you even want to go there. Because I mean, I'm just telling you, some of these kids are crazy. And some of these, we've had it where they make false allegations against our clients of really, really bad things. And it ends up putting our client and their other family members in very, precarious situations and sometimes criminal situations. And so my advice is always, let's get you guys into therapy. Let's get you guys to work through your issues. And then if you guys can work through your issues, then you can bring him into a safe environment. But trying to force a 17-year-old who's dropped out of school to come back to your house because you don't want to pay child support, I don't know, guys. I don't know if that's the best play.
That tough love sometimes,
Thank you, James.
but
I mean, I guess. I guess it could happen. I don't know. I would not want to be in that home when it did. So, Floyd, go.
Where are we here?
Oh, hold on. We had a question. What about child alienation from the other parent? So, touche, Mr. Carpenter. So, alienation it's actually a really big topic in courts these days, and it is something that we use quite a bit, that we discuss quite a bit, and that we actually argue quite a bit. I will tell you that it is very complicated to prove alienation. And you really have to have some evidence to support that contention. Coming in with this idea of my 15-year-old just hates me and I don't really know why, that's not going to be enough for alienation, right? What you're going to want is I've attempted on numerous occasions to see my child and the mother's never showing up. I have text messages where I've told her that I want to have a relationship with my child, and she has told me that, go to hell after everything you did to me, you'll never see him again. Those types of conversations, those types of actions, is what you're going to want to do, because you have to somehow put your child's feelings towards you on the other parent, right? It has to be their fault. That's the alienation component of it. And without those sort of things, how do you prove that it's really the other parent's fault and not just because you did something wrong to your child, right? Or your child just doesn't feel comfortable with you. And that's where I think, once again, the therapy component is so important, because number one, the therapy is going to help you to potentially heal that relationship with your child if you get a good therapist. And I have had some cases where I thought there is no way in hell that this son is ever going to, be great with his mother. And this therapist worked and worked and worked. And within about 9 months, they were having visitation and they were back on good terms, right? But the other trick to that was if mom had continued down this pattern of, being nasty and being ugly and so on and so forth, then we would have been able to say, well, look, this is not dad pitting the child against mom. This is mom just not working on her relationship with the child. And so it's mom's fault, not dad's fault, right? But through that process, the therapist also learned that the way that this child was feeling was not because of dad. It was because of this hardship that he had with his mother. And we were able, because the other side had been arguing alienation, we were able to get rid of that argument, because the child was like, listen, my dad supports my relationship. My dad talks, kindly about my mom. He doesn't say anything negative, but my mom has said this other stuff and done this stuff, and I just don't like her. I don't feel comfortable with her right now. So alienation is a thing. Okay, that is definitely something that can be argued, but we gotta make sure that we have the evidence. So Floyd, James, do you have anything else on alienation?
James, got anything?
Don't do it, parents. Don't do it.
Sound advice. Yeah, I mean, it's a terrible, terrible thing to do to the kids, right? I mean, it's terrible. It's difficult to prove, like Christina said. It's hard to prove, but it's a terrible thing. And if we're able to prove it, we generally have really good outcomes for our clients. It's just got to be set up correctly to be able to establish it. Like Christina said, counselors, things like that. The child over 12, let them go talk to the judge and see what the other party's been saying about them, about mom's been saying about dad, or vice versa. Let them tell the judge that. But if you can establish parental alienation, it's huge. No judge likes it, but it's difficult.
I had a case actually, where I was representing the father, and I didn't step in until about 2.5 years into their litigation. And the mother had primary, and at the time that we stepped in, he only had supervised visitation because the mother had, very competent counsel, and that attorney on several different occasions had made really bad allegations against the father, of the different drug use, abuse, things of that nature. And so when this gentleman came to me, he had final trial a couple months later, and I was like, listen, he wanted primary custody, and I'm like, there's no way, right? There's no way that we're gonna be able to get this thing done for you. And then he started showing me everything that he had, and it was crazy because what this particular mom was doing was she was filing a protective order on Monday, and on Tuesday was saying, hey, if you want to come and have dinner with me and the kids, then I'll let you see the children for 1 hour, but I want you to take me to dinner at this particular place. And we had several of these instances of, well, you're a danger, but I want to be with you, and I love you, and why won't you come back to me type things. And so what we were able to establish, and Floyd and I don't even know how many hours we worked on it, but getting this timeline together to go through and show the judge, look, judge, here's your proof of alienation. Here's all the times that she was using these children as a pawn to try to get her husband back with her. And after a 2-day trial, the court, that was like the first time that I had a judge actually say, I do find that this mother is guilty of parental alienation. And our guy went from 4 hours on a Saturday and Sunday to having primary custody. But I'm telling you, like, I can't even tell you how many hours that we went through where we put the evidence together, and then we're like, this isn't painting the picture, and we had to go and put it back together. We did it like 3 or 4 times, and at the end, it was just, this judge was not happy, and obviously the mother wasn't happy, but mom should have never done that in the first place, right? And like you said, James, just don't do it. It's not good for your kids. It's not healthy for them at all. So
I mean, a lot of times, I won't say a lot of times, but sometimes there are dads that come in, and most times it's dads, that's the reason I'm saying that, come in just frustrated with the process of mom keeping the child away, and up to the point of wanting to terminate, just, I don't ever get to see my child. I don't want to deal with this stuff anymore. And after talking through it with them, it's not that they don't want a relationship with the child. It's just mom is just making it way too difficult to do it. And I just tell them, like, look, it's going to take us some time. We're going to have to set this up properly. But if you want a relationship with your child, we'll make sure you have it, right? One way or the other, by enforcements and whatever, or she's going to be spending a lot of time in jail. But don't give up your rights just because things are difficult and you don't feel like you can have a relationship, because you can. The courts will give you that opportunity as long as you're not off doing drugs and things like that. But if a good parent really wants a relationship, they'll get it no matter how difficult the other parent is. So
right. Yeah. Those cases just make me so mad. It makes me mad because, not mad, like, I guess that's the wrong word, but it's frustrated because a lot of times that it's happening, but how do you show the judge, right? Because we get to hear and see all this background stuff that sometimes isn't admissible in court, right? And that's one of the things that I have all the time, where a parent will come to me and say, well, my son told me that his mom said that she was gonna keep him away from me and, oh, you know, do whatever she could so that I could never see him. That's not admissible in court, guys. And a lot of times we get that frustration from clients of, well, why can't you use this? Well, because there's this little book called the Texas Rules of Evidence that we have to make sure that we're following when we're in court. And so, yeah, but again, you want to go out, you want to seek good counsel, you want to, you know, have them listen to your particular fact pattern. And there's a lot of times for every, you know, 5 cases that I say, yeah, I think we have a shot at parental alienation, there's probably another 20 where I'll say, this just isn't enough to prove that, right? Doesn't mean we can't help you, because we can still get you set up with, you know, visitation and therapy and all that good stuff. And hopefully eventually get to a good place for you and your kiddo. So, alrighty, so next question. Is that on me or you, Floyd, or James? Me?
I think it's on me.
Go.
How much is a legal separation and time frame of getting one? I'm currently married but separated, living in Texas. I was wanting to buy a home, just my name only. My husband and I have no kids, no pets, nothing to fight over. I'm just not ready to get a divorce. So I think we've talked about this legal separation stuff before. That doesn't exist in Texas. There is no legal separation. The closest thing that we have to a legal separation would be temporary orders during the pendency of a divorce case, where it, you know, details, you know, who gets to use what property and kind of acknowledges that you guys are living separate and apart. But for your purposes of being able to buy a home in your name, you would still be married. It would still be considered community property. So the only way that you can buy a home in only your name and your husband not have any right to it is if you guys get divorced. Or if you do a partition exchange, right? That's the right terminology, right? Partition exchange.
Yes.
Yeah, I thought so. But aside from that, there is really no legal separation in Texas. You're either married or you're divorced. If you're married, community property. If it's purchased during the marriage, even if it's only in your name, and if you're divorced, obviously it's yours.
So, but the temporary orders will put a Band-Aid on their situation, right? So if they're trying to go through this process and you're trying to, you know, just figure things out and go to counseling, seeing how it is being away from one another, whatever it is, temporary orders will put a Band-Aid on it so that you don't have one spouse running off and selling all the property or running up credit cards or doing anything crazy, right? Typically in most courts, you can get a temporary order within, I don't know, a couple months. You'll be in court and have an order drafted. If you guys are coming to an agreement, then you can do an agreed temporary order. And the reason why it's so important to go through that process is because you have some accountability, right? So if you violate a temporary order, if a person violates a temporary order, then they're potentially subject to a contempt finding, right? And that means that you can go to jail for up to 6 months, and or pay a fine of up to $500 and have to pay attorney's fees. And so what it does is it sets up the rules and it sets up some accountability in case somebody decides they're going to break the rules. So if you're going to get a separation, don't just go your separate ways and just kind of try to figure it out. Try to get something in place, right?
So in this case, she's wanting to purchase the home solely in her name only, right?
Petition and exchange, and yes, absolutely.
I do like that question. You know, people willing to fight for their relationships, and she sounds like she still got some fight in her.
That's true. James, you're just a beacon of positivity this morning. You're so young and new to this whole thing.
And recently married, so is that
That's right. 29, recently married, love is in the air with James. Oh my goodness.
I do. I like it. She said she's just not ready. All right, well, come on, fight on.
Oh my goodness. Okay, so I guess I'll take this one, even though it's kind of hard, kind of tricky. Okay, so my mother never made child support on me. I'm now 29. Is there anything I can do about it? My mother left my father, and when I was 3 years old, she was ordered to pay support. It was in the divorce decree. To my knowledge, she never paid a dime. I'm not sure if there's anything I can do. My father recently passed away. I was wondering if there was a way to contact her or do anything about the past child support. It may seem selfish and petty, but it's something that my father was truly upset about. It bothered him until his last days. It's more curiosity than anything else. I live in Vermont, but I believe I found my mother's most recent address. I believe she's living in Irving, Texas. So the short answer is no, there's nothing you can do now. Floyd, you're trying to catch me. I saw it on your face to see if you're gonna mess up. No, the short answer is no. You only have 2 years until the date after a child emancipates to proceed with an enforcement after they emancipate. Yeah. Does that make sense? So after they emancipate, to file a motion. That's what I'm trying to say. And if you don't file within those 2 years, then it is waived. And so actually, let me think through this because that's for an enforcement.
I think it's the same for a confirmation.
Are you sure?
I said, I think.
Okay. Yeah.
If I can guess too, I thought the deadline for arrears was 22.
That's 4 years after. I
Have these handy dandy books.
Yeah.
Da-na-na-na-na. Da-na-na-na-na.
Yeah. Everybody, here's mine. Mine's on the floor, right where it should be.
Yeah, I thought
Yeah, so I think the arrears thing is 2 years. It's the same as the enforcement.
Oh God, my dad would be, he's probably having a conniption right now. Are y'all serious? Y'all gonna pull up the book?
Yeah, you're acting like you don't know everything.
Yes, Dad. I have this
We have to
whole
pretend. We have to pretend for the general community that we don't actually know everything to make us look like common folk. Okay?
yeah, we're relatable attorneys.
So we'll flip through these books, act like we're looking for something, then we'll give them the answer that we already knew. Well, do you want to go on to something else and I'll look this up, or do you want me to go on to something else and they're not sitting here watching us read?
Why don't you go on to something else since this was my question, and
Okay.
I shall get the correct answer.
Well, actually, I believe James is up. So
Okay.
go forth, senor.
All right. So I'm a father and I want to put myself on child support. What do I do to start this process? I do not want to be with the mother of my child anymore. I'm fixing to leave her, but not until I out myself on child support. I'm not about to wait until many years later and still have to pay back pay. No thanks. I'd rather just be responsible right now and start paying child support right now. By the way, I'm a disabled veteran, so what process do I need to do to put myself on child support? Well, thank you for your service, sir. We can start there. And there's a couple different ways you can go about this. Do see that you're looking to do a responsible thing and put yourself on child support. So you could go directly to the Attorney General's website, fill out that information, let them know that you are seeking to start the child support process. However, it's going to be very cookie cutter, if you will. They're not going to ask you about possession. They're not going to ask you about access. So which leads me to the second way. You can go about doing this by hiring a private attorney, and you sit down, have a consult, and that private attorney, if they're a good one, they'll ask you about your relationship and your goals with the child or children, and how often you'd like to see each other, whether you actually want primary. And those questions not only will put you in a better position, in my opinion, but they could also have an effect on the amount of child support that you end up paying. So those are a couple ways that you can go about doing this.
Okay, so which way do you think is the better way, James?
The better way, the best way, I would say, probably don't do it and work something out between you and your significant other. That was predictable. All right, but between the other two, I'd go with a private attorney. And I know people are gonna say I'm biased, but I mean, you get more bang for your buck, literally. And it's the details, really, the details. And the big thing is that the attorney general is not going to be your attorney. So they're going to represent the state, whereas your private attorney is going to seek your interests and more so that of your child. And so, I mean, short answer, you go with the private attorney. It's going to be a little bit more expensive, but in the long run, has potential to pay off a lot bigger.
Yeah, I agree.
So with regard to the AG, Floyd, are you still looking this up? Because I'm struggling to find it.
Yeah, me too.
I know I've read it. Okay, so I found, well, I guess we'll come back to this. Yeah, I was right. So, but keep looking because I might not be right, but I think I'm right. I said that with such confidence there for a second. My husband always tells me, you're so impressive because the way you say things, like you just really know you're right and you have no idea what you're talking about. But I think I'm right. So the Office of the Attorney General, I think they serve an absolutely great function because what you can do, if you are not somebody who has access to private funds to hire a private attorney, you can go there, you can fill out an application, and if you're mother or father, they will help you to facilitate this process so that you can set up a suit affecting parent-child relationship, right? So it'll talk about your visitation, conservatorship rights, child support, so on and so forth, right? And so it is definitely very helpful, but like James said, they're not your attorney, and they're very clear about the fact that they are not your attorney. What they are there to do is they're there to act as a aid to the state to make sure that people are supporting their children, right? Because if people are not supporting their children, then they end up a liability of the state, and the state doesn't want that. So they'll set everything up, but they typically have, their standard guidelines that they'll follow. And if you're the father, let's just say, hypothetically speaking, it's dad that's getting visitation and dad is the obligor. If you're the father, you are going to, they'll look at your pay record, they'll set you up on child support, they'll talk to you about insurance, and then a lot of times, depending on the age of the child, they'll just do like your standard visitation, right? So if you want any extras, never gonna happen, right? If you're the mother, and this is a big thing that I see a lot of times with moms, with the Office of the Attorney General, is they will just look at a pay record and they'll say, all right, well, he's making, $20 an hour, that's your child support. And the mother's, jumping up and down saying, well, hold on, I know that he has this, he does private work, he gets paid cash, or he has this other company and it's in his wife's name, but he's actually, earning money on the back end, and I know it's actually his. When you start getting into those types of crazy situations, then you most certainly need to or should hire a private attorney. If you're okay with things just kind of being standard, then the AG is probably okay. And what I always encourage people to do, if they come and they consult with us and they're kind of on the fence, then I always tell them you can go to your first meeting, because a lot of times the AG will set up like a settlement conference, basically. Go and kind of see what the other side wants, what they're willing to offer. You tell them what you want, and if you guys can work it out there, then by all means save your money, right? But if after that first meeting you kind of realize, oh crap, well, he wants all this visitation, or oh no, she wants all this money, then at that point you need to lawyer up so that you can make sure that you're getting what you want, because the state isn't gonna care, right? So Amber says, would it not be if the child is 18 or when they finish college, whichever one is stated in the decree? So that's a great question, because we get that question a lot. We're going back to the child support issue, guys. A lot of people ask us that, like, can you make him pay child support after the age of 18 until they go through college? So the short answer is, if it's an agreement, yes, you can make them do that, okay? If it is, and I guess let me put a caveat on that, because if they agree to pay child support after the child turns 18, then if they don't pay it, that's actually, you can't hold them in contempt of court. Okay, because that's now a contract that you two have, and so there won't be any potential quasi-criminal liability for not making those payments. You can only enforce it as a contract at that particular point, even if it says that in the decree, okay? But for the contempt action, Floyd, and for the confirmation of arrears, did you find anything else? Because all I'm seeing is the 2 years.
No, so what I found is the contempt is 2.
Okay.
Confirmation of arrears is 10.
This person's still out of luck.
No, they're off their 29. 18 plus 10 is 28. Yeah. Maybe they graduated high school later. Maybe they graduated high school later because it's from the date of emancipation, which is what I was thinking. Like, maybe he graduated high school late. Let's hope.
Okay.
Right.
Right. It's not that you don't know simple arithmetic.
Right. Okay. No, I'm trying to give this guy a chance to get this money.
Late birthday, got held back a year. I'm with you.
Thank you, James. Got held back.
Okay.
You've got a chance, sir. You need to hire a good attorney.
If you act today.
Oh, now. Well, so okay, let's just say maybe there's a chance. I don't know. So then I guess he can file a motion to confirm arrears. Yes. Okay. And so he files a motion to confirm arrears. He sets them, and let's, I guess, back up just a little bit, because what we are looking at is we have to determine where the original order was, right? Because he says he thinks that his mom's living in Irving, but he was originally, well, he lives in Vermont. I don't know where he was whenever he and his parents got divorced. So he's going to have to.
I just want to point out, Mr. Rodriguez has it right. 18 plus 10 plus graduated late equals 29. Thank you, sir. You get me. All right, go ahead.
Floyd.
I am.
Thank you, Justin, for helping him out. He needs all the help he can get. Okay, so We don't know where the original order stems from, right? And so if the order is, you know, out of California or wherever, that's gonna be different laws, different whatever, different rules. But if it was in Texas, I guess you can file a motion to confirm arrears. And then I guess if she doesn't pay it, Floyd, what's the recourse?
I think it'd just be the collections recourse, right? So liens and that kind of thing.
Things like that. Yeah, because you can't hold her in contempt of court because the court loses what they call exclusive jurisdiction over the child to be able, or subject matter jurisdiction to be able to hold her in contempt. So you would get a judgment, and then there's all sorts of different things that you can try to do. Like if she has property that's not her homestead, you can put a lien on that property, try to levy that property. There's all sorts of different stuff that you can try to do if you want to do that. But I think that's sad, right? Like his father passed and he's worried about the child support. And I guess like if he's trying to avenge his father.
Well, I mean, she hasn't paid since he was 3. There's a big bankroll to be had.
Well, maybe. We have no idea what the order was.
Right, but even if it was a minimum wage, right, that's $2,000 a year.
Oh, now you're gonna do math? Really?
Yes. I can only do complex math. So minimum wage, it's about $2,400 a year times 15 years. You know, you're looking at about $36,000 ish.
$2,000 a year times 15 years.
Yes. Right, so that's 30 something. Then you have the 400 times 15, which is 6,000. So 36,000. Is that right? 2,400 times 15.
Oh, you're doing 24. Okay, you said 2,000, Floyd.
Well, then I changed it because I was thinking $200 a month. I was actually trying to get my math correct since you called me
Okay,
out.
I got you. Okay, you're good.
So $36,000, you know, pay for the father's funeral, you know, and all that kind of stuff. There's some money there.
Yeah, it's just sad. I don't know. Sometimes what we do is just sad. Alrighty, whose turn is it? Is it back on you, Floyd?
Oh God, I don't know.
I think I had the last one.
Yeah, I think it's back on you.
What can I do about child support arrears? My children are both grown in their 20s. I was estranged from my kids for approximately 10 years and missed out on so much because my vindictive ex-husband. Wages and taxes have been garnished, and I am at a loss with my arrears continuing to accrue. Is there any way to appeal or fight this case, or am I going to continue paying for the rest of your life? You will continue paying for the rest of your life. Unfortunately, there's no way you can go back and retroactively modify it at this point, and so the arrears are what they are. Your best thing you do is maybe reach out to him, see if you can negotiate some type of settlement in full for some cash, you know, something like that. Figure out a different way to handle it, but your remedies through the court are non-existent, but maybe you can get some type of an agreement to get them taken care of. Sad, not she kept them away for like 10 years. That's crazy, but it is what it is. You got to pay.
So going back to your agreement thing, we've done this before, where, you know, somebody owes like 20,000 in back support. We will work out an agreement where we'll pay $10,000 now in exchange for 20,000 over the course of, you know, 20 years. And that works. I mean, people, both sides are typically pretty happy with those sorts of agreements. But if the other side doesn't want to accept it and they want every last dime, well, then you're gonna have to pay it. And I would pay it off as quickly as you possibly can because it is accruing interest every single month. And you know, when you have, I've seen that before where people owe like $10,000 and they're paying $25 a month towards that $10,000 judgment. at that point, you're not even paying the interest. And so you really have to start attacking that payment as quickly as you possibly can. So, okay, I guess this will be the last one. If my boyfriend is paying child support and lost his job, why is payment the same? He lost his job on August 5th, 2021, and is now helping out friends. However, he isn't getting paid what he was getting paid before. Can payments be lowered? If so, how and who do we contact? You contact a lawyer, and you have to file a motion to modify. And basically, the argument is he's making less money than what he was previously making, and therefore we need to modify the order. And there's certain, it appears as though he is, I mean, he's helping out friends. So I guess, is he on payroll? I don't know. Or is he just getting cash? I don't know what's happening there. But if he's just getting cash and he doesn't really have anything to document his income, and let's just say, hypothetically speaking, he says that he's only making minimum wage, right? Then they'll reduce it all the way down to minimum wage. If he is getting some sort of pay record, then they'll look at his pay record, they'll calculate the new child support payment after or at that time. If you go to the Office of the Attorney General's website, they have a link where you can actually calculate your child support. And we can post it here on Facebook here in just a second, where you can go in and you can plug in, you know, number of children that you have, the number of children that you're actually going to be paying support for, the amount of health insurance, plug in your gross wages, and then from there, it will tell you this is how much your child support obligation should be. Because I can't tell you the number of times that we've had people come in and do consultations with us, and they're like, oh, you know, I had 3 more kids, and so my child support should go down, right? And we go through and we run the figures, and we're like, you actually don't want to file this, because if you do, your child support's going to go up because you're making more money than you were making a few years ago. So it's a good practical exercise to either run the calculation yourself or go into a consultation, and then they can run those calculations as well. But we have that happen quite a bit, where people lose their jobs and they don't file anything with the court. And so what's happening is all these months are going by, and it's just racking up a big chunk of change that you're going to eventually, like you saw in our last question, when your children are grown and in their 20s, you're still paying that support, right? So I understand that lawyers are expensive, and that, you know, sometimes, especially if you've just lost your job, you don't want to pay an attorney to go in and file a motion. But if you don't, you're going to end up in some of these situations where either your son's 29 trying to come and sue you, or you're still paying all sorts of money when they're adults, and that sucks. So call an attorney. Cool.
Agreed.
Anything else? Any other questions or concerns?
There was one question I had with regard to the lady who owes a whole lot in arrears. So, you know, much of the job is negotiating and trying to find an agreement outside of, you know, getting those two together. Say she would come in. I mean, I just question, how would we look to get an agreement settled? I mean, we don't have much leverage outside. Maybe the kids, getting them to come speak with Pop. Hey, Pop, come on, let Mom off the hook.
I mean,
Oh, you know that saying, cash talks, BS walks, right? So if you bring someone $10,000 cash for the versus the potential to get 20,000 later, right? They're like, give my cash now, right?
so isn't it like a bird in the hand is better than 2 in
The
the
bush, I heard that one.
Thank you.
That's
Yeah.
true too.
I was gonna say the nest, but I mean, it could be a bush as well.
Yeah,
It was definitely the bush. That's the saying.
bird in the hands with 2 in the bush. Okay,
Right. Now, James, did you get the point?
I got you.
So that's how you spin it. Otherwise, they may never collect the money, so they can get it now. So that's it. That's all you have. So, all right. Well, like we say every single Monday, as we're going through this stuff, it is not meant to be legal advice, right? You guys, as you can tell from the fact patterns that we go through and the questions that we're answering, very specific information, and it's really those nuances that can change the response to any particular question. So it's always so important that you take the time, go and visit an attorney, tell them your story. And actually, let me post up a little disclaimer while I'm saying all this good stuff. You go and you visit with a good attorney, have them answer your particular questions about your particular fact pattern, because it's always going to be different. And it's always going to be different whenever different attorneys are looking at a question, as you can tell by our little song and dance that we do on Mondays. So I appreciate you guys tuning in, and Floyd and James, I will see you later.
All right, toodles.
Bye.